thuốc gì đó Good afternoon, everyone, and welcome to today's event. We're delighted to have you join us for this critical discussion on the human rights impacts of administrative counterterrorism measures in the MENA region. This event is sponsored by the American Bar Association Center for Human Rights and MENA Rights Group. Before we begin, let me state that today's discussion reflects the views and expertise of our panelists and should not be viewed as representing any ABA policy. I would also like to mention a few logistical details. We have interpretation available in both Arabic and English, with Channel 7 for Arabic and Channel 2 for English. This event is also being live streamed, and the recording will be accessible on MENA Rights Group's YouTube channel. I would also like to kindly remind the audience to refrain from taking any pictures, except for those assigned by the organization. Administrative counterterrorism measures that include administrative detention, travel bans, and citizenship stripping are increasingly used to target activists, civil society organizations, and political dissidents. While these measures are framed as necessary for national security, their expansive use raises serious concerns about their impact on fundamental human rights. In just a few days, on the 18th of September, the UN High Commissioner for Human Rights will present his report on terrorism and human rights at the 57th session of the Human Rights Council. His report will address the use of administrative measures to counter terrorism and detail their impact on human rights. And so our objective today is to build upon that report by discussing the detrimental impact of administrative counterterrorism measures, specifically in the MENA region. We will highlight how these measures are often weaponized against individuals and organizations, leading to severe violations of human rights and fundamental freedoms. Moreover, we will explore potential strategies to mitigate these adverse effects and seek alternative solutions that ensure both security and the protection of rights. I would like to now introduce our esteemed panelists. So first we have Tanya Bulakovsky, Human Rights Officer covering the counterterrorism and human rights portfolio at the MENA Rights Group, a Geneva-based NGO defending and promoting fundamental rights and freedoms in the MENA region. Samar Khamis, Human Rights Officer at the OHCHR, whose work notably focuses on counterterrorism and human rights. Abdullah Al-Ruwauji, Monitoring and Campaign Officer at Al-Quds for Human Rights, an NGO which defends and promotes human rights in Saudi Arabia. Next, we have Ahmed Al-Nuaimi, Emirati human rights activist who was tried in absentia in the country's largest mass political trial, known as the UAE 94 trial, and is currently being tried in absentia in the UAE 84 trial for terrorism offenses. And last but not least, we have Yasmin Al-Hassan, International Advocacy Coordinator at the Union of Agricultural Work Committees, a Palestinian NGO supporting and protecting the rights of Palestinian farmers. So to begin, I'd like to first start off by asking Samad and Tanya to set the scene for us. Samad, could you start by giving us a general understanding of what administrative counterterrorism measures are and what their impact is on human rights?
Hi, thank you so much. So my name is Samar. I work at the OHCHR, and I'm happy to present the High Commissioner's report on terrorism and human rights. It was submitted pursuant to the last Human Rights Council resolution on terrorism and human rights. And as mentioned by my colleague, our report, it's the first actually UN report that looks at the use of administrative measure in counterterrorism. It has a global view. It reports on the recurrent types of measures used in counterterrorism, the administrative ones. It assesses their impact on human rights and provides recommendations to all member states and UN entities. So let me just share a few findings of the report. The report does not seek to provide an exhaustive list of administrative measures, but we do note that there are administrative detention, travel, terrorist listing, movement restrictions and travel bans, as well as mass surveillance and deprivation of nationality as key measures used in counterterrorism outside the confines of criminal justice system. We also note that a generally accepted definition of administrative measures is absent, sometimes termed as executive or non-criminal measures. and often refer to coercive measures that may restrict certain human rights without laying criminal charges. Now, administrative measures are a priori preventive in nature. In our report, we note that some measures may be characterized also as punitive due to their nature, intention, and extensive human rights impact, even when presented within a administrative legal framework. Certain administrative measures impose restrictions on human rights that are similar to those emerging from the criminal justice, from the criminal law. The problem, however, is that the administrative measures would not necessarily trigger the application of legal safeguards used in criminal justice. The report reveals persistent issues related to safeguards and oversight when applying administrative measures, and I'll give a few examples. In relation to terrorism listing, we have noticed that in many countries, guarantees of transparency and access to information is often an issue. Sometimes people who are included on terrorist listing do not know of that until they try to exit the country. And even then, information on listing grounds and ways to challenge the listing decision is not so straightforward. Another worrying measure concerns the use of detention without trial. We stress in the report that administrative detention is being used in many countries for lengthy periods during which no judicial review is permitted. Some detainees continue to spend years behind bars without facing any criminal charges and not able to challenge the legality of detention. In some country contexts, preventive detention is imposed immediately upon the completion of a conviction sentence. Both the Human Rights Committee and the Committee Against Torture criticized the broad law enforcement's powers, especially when imposing preventive detention. I would like just to highlight another two common administrative measures that we came across in our research. First, mass surveillance. Indeed, many countries have expanded the powers of law enforcement and security agencies to conduct surveillance. Surveillance by nature poses serious risks to the rights of privacy and non-discrimination. And therefore, effective safeguards, procedural safeguards, and oversight become all the more essential to avoid misuse or overuse of executive powers. Nevertheless, the High Commissioner notes in our report that in many states, limited safeguards and ineffective judicial oversight continue to be reported regarding the imposition of executive surveillance order. Finally, on deprivation of nationality. In the context of countering terrorism, we've noted that this measure is often used to address the threat posed by foreign fighters. And here also, lack of sufficient transparency when imposing such decisions is often the case. The use of secret evidence is not unusual in such proceedings, while some proceedings are held in absentia. This undermines the principle of equality before the law, the right to an effective defense, and the individual's ability to challenge the measures imposed on them. And due to the far-reaching implications on human rights, perhaps the deprivation of nationality best illustrates the blurred line between administrative and criminal measures used in the context of countering terrorism. The severity of the measure, even if formally considered as an administrative one, can be seen as pointing to the punitive nature of the measure. The High Commissioner report highlights other human rights implications, specifically the high risk of stigmatization of individuals subject to those measures, as well as the entire community they belong to. In addition, the impact on civic space and the targeting of a wide range of civil society actors is also highlighted in the report. Lastly, the report notes that there is little work undertaken by states to evaluate the effectiveness of administrative measures. It is indeed a challenge to demonstrate a direct causal link between the implementation of an administrative measure and the prevention of a terrorist attack. Yet, evaluation is crucial, given the asymmetry between the certainty of the measure's impact on human rights and the uncertainty of security gains such measures produce. I will stop here. I will come towards the end of the session to share with you some of the conclusions and recommendations provided by the High Commissioner, and I look forward to engaging in discussion during and after the session. Thank you.
Thank you very much, Samar, for this high-level overview of the findings of the report. I'd now like to turn to Tanya. Can you give us an overview of the administrative counterterrorism measures which are imposed across the MENA region specifically, and explain the legal and institutional framework that they fall under?
Thank you. So at MENA Rights Group, the most prominent pattern we have observed in the region is the use and abuse of counterterrorism laws and policies to target and silence individuals and organizations solely in reprisal for the peaceful exercise of their fundamental rights and freedoms. Every day, we document more and more cases of activists, dissidents, human rights defenders, journalists, lawyers, and civil society organizations being accused of terrorism. Acts that we typically see being labeled as terrorism can range from participating in a peaceful protest, denouncing human rights violations as a civil society organization, or posting a tweet from an anonymous Twitter account. Victims of this counterterrorism abuse are subjected to human rights violations such as arbitrary detention, torture, and enforced disappearance in a climate of complete impunity. At the root of the problem, at the national level, we see three key issues. First, we see that domestic counterterrorism laws contain overly vague and broad definitions of terrorism, typically relying on ambiguous terminology such as public order, national unity, or state security, which fail to comply with international human rights standards. Second, we see that the entities in charge of enforcing these laws, such as state security apparatuses, operate with excessive powers and without oversight. This allows them to label nonviolent acts as terrorism at their discretion. Third, we see that exceptional jurisdictions, such as specialized or military courts set up specifically for terrorism cases, lack judicial independence and fail to uphold fair trial guarantees and due process rights. So it is in this deeply flawed, non-human rights compliant counterterrorism context that we come to understand administrative measures. So through our work at MENA Rights Group, some of the main administrative counterterrorism measures we document in the MENA region include administrative detention, terrorism listing, travel bans, and citizenship stripping. So to give you some examples, some administrative measures can be imposed alongside criminal law or as a prolongation of criminal penalties. So for instance, in Saudi Arabia, the counterterrorism law provides that terrorism convicts who are handed a prison sentence will also automatically face a travel ban for a period matching their prison sentence following their release. In the United Arab Emirates, or the UAE, Munasaha centers, or so-called rehabilitation centers, are de facto prisons which are used to detain individuals accused of terrorism after they have already served their prison sentences and keep them in detention indefinitely. Another important element is the exceptionalism that is inherent to cases of terrorism. For instance, in Algeria, according to the law, a travel ban can only be imposed for a maximum of 3 months, renewable once. However, this rule does not apply for cases of terrorism, where the ban may be renewed indefinitely. Another key human rights concern is the secrecy surrounding these administrative measures. For instance, in 2021, Israel designated 6 Palestinian civil society organizations as terrorist organizations on the basis of secret information. This designation was enabled by Israel's counterterrorism law, which allows for secret evidence to be used as the basis for permanent terrorism designation. This lack of transparency also extends to other measures. For instance, many individuals only discover that they have been subjected to a travel ban upon their arrival at the airport when they try to travel, without prior notice nor formal explanation. As a result, they are placed in a state of legal limbo and are unable to appeal since no formal decision exists. And also, families, including children, spouses, brothers and sisters of victims of counterterrorism abuse, are also punished by these measures simply by association, although they have absolutely nothing to do with the acts their loved ones have been accused of committing. So for all these reasons, it is crucial to recognize the profound impacts of these measures and to listen to civil society voices from the MENA who are directly impacted, including those on our panel today. So I'm honored to give them the floor.
Thank you very much, Tanya, for highlighting the overview of the legal framework surrounding these counterterrorism measures. Next, in this next session of the panel, we'll hear from civil society voices from MENA countries about their firsthand experiences being faced with such measures. I'd like to start off first with Abdullah. You work at Al-Quds for Human Rights, which defends and promotes human rights in Saudi Arabia. A few months ago, in March 2024, UN Special Procedures expressed concern over the continued administrative harassment in the form of a travel ban imposed on Saudi human rights defenders in relation to their peaceful human rights work. Can you tell us a bit more about how travel bans are imposed in Saudi Arabia and share insights about their impact?
Thank you so much. First of all, I would like to thank to MENA Rights Group to organizing this important event. And my speech will be in Arabic. مجددا أود أشكر منظمة MENA.
Once again, I would like to thank MENA Rights Group for hosting this side event on this highly important topic, travel bans. Every follower and observer of the human rights situation in Saudi Arabia knows the extent of the increase in repression, arrests, and travel bans affecting various segments, and especially in the latest period. And this amounts to travel bans or even harsh penalties reaching the point of the capital punishment for charges which could not be considered as violent acts. This increase came after Salman bin Abdulaziz assumed the throne, and then his son Mohammed bin Salman became a crown prince. And this was slightly diminished after international pressures were exerted on the Saudi authorities after the assassination of Jamal Khashoggi. Then it returned to rise more strongly than before after the Russian-Ukrainian war, which was considered by the Saudi authorities as an opening for them to carry on their interest and their policies, their old policies, especially that these Gulf states are funding and supplying the warring parties with oil and while they continue their repression. The Saudi authorities always seek to polish their image and try to show the world that they are open and are amending many of their laws to suit and contribute to achieving the economic vision, Vision 2030, which aims to diversify resources of income and attract foreign investment to Saudi Arabia. And they are saying that their laws are being amended to suit this vision. However, on the ground, what the population and the non-Saudi residents from developing countries are experiencing shows that there is a different reality that goes contrary to what Saudi are claiming, and which remains only ink on paper. I would like to focus now on travel bans, arbitrary travel bans, as many legal NGOs are looking at this matter. The Saudi authorities often use this punishment arbitrarily against individuals, and we do not have the actual numbers, as the individual themselves may not know that they are under a travel ban until they reach the airport, until they try to travel. Once they reach the airport and try to cross the border, then they are informed by the customs agent
عليه منع من السفر.
by the border agents that they are subject to a travel ban.
الموظف نفسه لا يعلم
Even the border agent does not know what are the considerations of this travel ban and what are the reasons for such a ban. All they know is that you are on a listing and you have to go and contact the state security apparatus to inquire about it. Once an individual goes to see to the state security apparatus, they have to inquire with regular officers who themselves cannot find the right information and the reasons for their travel ban. Fortunately, these cases of travel ban are happening arbitrarily, and we have one case in point here we can talk about Abdulaziz Al-Muzaini. He's a Saudi American citizen, founder of the Mirkot company, an animation production company, who was surprised to find out that he was banned from travel for some time. After that, he was summoned to the Ministry of Information, which filed a case against him, accusing him of, and his company, Mirkot, of having produced an animated series called Masamir. And among the charges is that Masamir supported ISIS and homosexuality. And it was very absurd to see that these two charges were included against the same person. And then this person discovered that he was subject to a court case dating back to 2011. And this is more than 10 years ago. Throughout that period, as we may well know, in that region, there were the Arab Spring waves, and the Saudis felt at the time that there was a margin for freedom, where they could talk about economic, social, and political situations. During that period, they were tried for tweets that they wrote in 2011, and they were then subject to travel bans. And many of those who were detained or subjected to travel bans, when they were tried in 2011, they were underage. They were under the age of 18. And authorities detained those who tweeted or expressed their opinions at the time when their tweets were not considered illegal. And this was prior to the rule of Salman bin Abdulaziz and his son. And they were underage at the time. Unfortunately, the Saudi authorities are resorting to such punishments. And certainly, when any prisoner of conscience is released, especially prominent ones, we at legal NGOs rejoice, and human rights organizations do rejoice. But there are so many of these cases of travel bans that persist against them. And usually these these travel bans are equal in time and period to their prison sentences, in addition to their prison sentences. And let me go back to the case of Abdulaziz Al-Muzaini, who was subject to a 14-year detention, and his travel ban was for 13 years, which means that he could only leave Saudi Arabia 34 years after his trial. Is this something conceivable? There are many people who are released from detainment and who are still being subjected to such travel bans, such as Lujain Al-Hadloul, who was released and allowed to travel outside. However, after having been released from prison, they were still subject to travel bans. In the case of Lujain Al-Hadloul, she was banned from travel last year after having served a sentence of 5 years. And after her release, she is still unable to travel.
منع من السفر بشكل غير قانوني.
As an illegally issued order of travel ban was issued against her, and she doesn't even know the period of that sentence. In August 2023, a group of Saudi expats sent a letter to the Saudi Human Rights Authority, which is a government authority claiming to promote and defend human rights. Those Saudi expats, among which Nina Al-Hadloul and Dr. Abdullah Al-Auda, who who has 19 members of his family who are under a travel ban in Saudi Arabia, and the family of Nasser al-Qarni, who is also under a travel ban, and Khaled Jabri and Maryam al-Utaybi, and her sister Manal al-Utaybi, they are all under a travel ban. When we discuss travel bans in this context, it is important to point out that the Universal Declaration of Human Rights stipulates that every person has the right to freedom of movement and to choose their place of residence within the border of their state, and the right to leave any country, including their own, and to return to their country. And this is by virtue of Article 13 of the Universal Declaration. Saudi Arabia has ratified the Arab Charter on Human Rights, and Article 21 states that no citizen may be arbitrarily or unlawfully prevented from leaving any Arab country, including their own. And also Article 6 stipulates that there can not be a travel ban except by a court order and with a clear specification of the specified period. Thank you. I will stop at this point. Thank you very much, Abdullah.
Turn next to Ahmed. As an Emirati human rights activist, you're currently being tried in absentia in the UAE 84 trial for terrorism offenses, for peacefully advocating for democratic reforms in the UAE for over 10 years. You were already tried for those acts and sentenced to 15 years of imprisonment in 2013 as part of the UAE trial, the country's largest mass political trial. You and many other defendants were members of the Al-Islah group listed by the UAE as a terrorist organization in 2014. You yourself were also added to the UAE's national terrorism list in 2021. Can you give us an insight into how terrorism listing and other administrative measures were imposed on you and how these measures have impacted your life?
Hi, everyone. I'd like, first of all, to thank MENA Group, MENA Right Group, for organizing this event and for having you as well with us today. My speech will be in Arabic and it will be translated.
Well, the story about what is happening in the UAE, it's not just mine, and it is a matter of violation of human rights in the UAE. I'm going to expose this through my own personal story. Although we might understand that this story started with some human rights claims from a group of UAE citizens who claimed their human rights in political participation. And as a result of this, they were accused of terrorism. They were accused of terrorism for anyone who supports this idea, whoever claims democracy, whoever claims the human rights of an individual to have a freedom of expression. And of course, the UAE government relies on the fact that any claim for rights is considered to be terrorism, even if it's just a tweet. And I was amongst those who were claiming such rights, and my life got impacted heavily. Anyways, I would like to tell you that I am a father for a son who lost his life in 2021 and who could not join his parents because he had a travel ban. And the travel ban was the result of the accusations held by the UAE government towards us. And what happens actually is that this a child actually was suffering from polio, and he could not join his parents. He could not stay with them. He stayed for many years far from his parents, and he was nurtured. He was not nurtured by the love of his parents. And this is the result and the outcome of what the UAE government is undertaking. And this has impacted our society nowadays. I'm just talking about one son. Nevertheless, this applies to the rest of the family. family, and the family, the rest of my family who could not join me until 2 years later. And it was actually not just suffering to access my home and to reach me. And I am still in Great Britain. I was living back then also in Great Britain. So this is what we know. And many outcomes resulted from this. And my name was added to the terrorist lists. And this has impacted heavily my life. And just in the UAE, just to let you know, nothing was renewed for me, neither for me nor for my family, my spouse, my children, even my siblings, my mother. Everybody is impacted by these sufferings. My mother, who is now 93 years old, has a travel ban as well. It's not just my own suffering. It's not just my own suffering. This applies to anyone who claims rights in the UAE. And these are the sanctions that he is faced with. This is why the image of the UAE in the media is a bright image, being the country of law and the country of freedom. This could be true, but this is being repeated for those who are in the diaspora or even inside the country, and this is being repeated. This is why I could not even control my properties, my own properties, house, car, you name it, company, whatever. They expropriated me, and even after the death of my father, I could not even reach out to him before he died. Even the heritage actually was confiscated. I could not even access my heritage, and this actually this remains blocked. I cannot even deal with my heritage. It is confiscated. And anyways, you might think that we did not try to reach some compromise. Not at all. But every time, at every attempt, they were starting with a completely novel idea about the idea and the nature as well as the definition of terrorism in a new way. Well, of course, all my bank accounts were frozen and I could not reach any bank account I owned. And moreover, there is always provocation, and not just against us as individuals, but also on our families. So what we have reached today because of this problem goes beyond the state, because every time there is a new trial within the state, there is a trial in the UAE. There was a trial in 1996, and this was again in 2013, and now again we are charged one more time that was last year in 2023. There was a new trial. Actually, it was repeated. So this in law does not exist. You cannot repeat a trial. Nevertheless, this has happened indeed. As a result of this, we are suffering greatly. I myself with my sons, and it is like a spiral of events. And just to give you an example of what has happened in terms of sufferings, when I return home to Great Britain, I will be halted at the Great Britain airport, and this is what happens with the governments that cooperate with the governments. I might be arrested there, and there is pressure that is exerted on me. It is unbelievable. I remember the last return I had with my family after our summer holidays. Actually, we were stopped at the airport for 3 hours and a half at the airport in Great Britain, and there was no reason for such conduct. And then, of course, they had to inquire and so on, and then they left us free to return. Thank you. I will stop at this point. Many thanks, Ahmed, for sharing your story as well as the impact of such measures on your personal life.
You work for the Union for Agricultural Work Committees, which was among 6 Palestinian civil society organizations that Israel designated as terrorist organizations in 2021. UN special procedures have condemned this designation, describing it as a misuse of counterterrorism measures by the government of Israel, undermining the security of all. Can you share any insights into your experience regarding this terrorist designation and any other administrative measures that Palestinians are subjected to? and what have the impacts of these measures looked like?
Thank you, everyone, for being here. So, Israel is a settler colony, and settler colonialism, as we know, it entails the elimination and the forced displacement of the indigenous population and replacing them with a settler population. So the basis of settler colonialism is land theft. It is all about the land, which in turn means the dispossession of land for the indigenous people. And in this case, that's us, Palestinians. And that means that any organization, individual movement, or other type of body that pushes against the oppression of settler colonialism or contests the dispossession of our rights, land, resources, that to a settler colonial entity poses a direct threat. Which is why the Israeli occupation views civil society organizations as an existential threat. Civil society organizations that have been working for decades to defend Palestinian rights and advocate for our liberties and freedoms. The Union of Agricultural Work Committees, or UAC, has been long targeted by the Israeli occupation for our work on Palestinian land sovereignty. And on October 19th, 2021, the Israeli occupation designated 6 leading Palestinian civil society organizations as terrorist organizations, including us, UAC. The Israeli military raided the 6 offices in Ramallah in August 2022. For UAC, it was the second raid. The IOF, the Israeli occupation forces, destroyed and stole property, made a mess of our entire office, boarded the doors, left a military order attempting to shut us down. And they also raided our fridge, stole our toaster, naturally. Following the designation, there was a massive international solidarity campaign in support of Palestinian civil society. This included countless statements by international bodies, organizations, political figures, grassroots movements, condemning the designation, including from the UN. And all of this is backed, of course, by multiple independent and conclusive financial audits, reviews. Now, I'm not going to give the designation legitimacy by debunking it, and to be honest, it's quite silly and far too easy. And you can just read the UN statements condemning it. Honestly, I'm not sure how Israel wasn't embarrassed to publicly state that they're scared of us, but that's for them to deal with. UAC supports the steadfastness of Palestinian farmers, peasants, fisher people, and rural communities in the face of the Israeli occupation. And we work to protect and defend Palestinian food sovereignty despite the Israeli dispossession and exploitation of Palestinian land, water, natural resources, and livelihood. It is very important for me to note here that our work with the land is not abstract. Neither is settler colonialism. Our work with the land is very material. Our presence on the land is material, as is settler colonialism. Palestinian communities are rooted in the land. So UAC's work, our material work with the land, preserving our physical presence on our land and thus resisting the active and ongoing settler colonialism, this scares the occupier. Their goal is to make our survival as the indigenous people and the sustainability on our land impossible. And we refuse to allow that to happen. We are caretakers of our land. And the Israeli occupation is, by definition, oxymoronic with Palestinian liberties and freedoms and basic human rights. So the Israeli occupation views us as a roadblock. These types of terrorist designations are much more than just a misuse of counter-terrorism measures. Rather, this exemplifies the fundamental issues with the entire framework of these terrorism designations. This framework is rooted in authoritarian and imperialist ideologies and mythologies. No matter where we are in the world, whether it be these terrorist designations by Israel or CVE measures in the US or wherever we may be, what legitimizes 76 plus years of Israeli settler colonialism and violence against Palestinians and prevents the UN from calling that terrorism? What legitimizes the American active involvement in the genocide and prevents us from calling that terrorism? Whose security do these counterterrorism measures protect? if it has allowed for a genocide, and if the system permits all of that to continue without repercussions, but designates us as terrorists, then what is the purpose of that system besides to protect the state actors and interests that continue to murder and exploit us? The criminalization of Palestinian civil society is a performative move. And the Israeli occupation criminalizes much more than just our civil society. This is part of the broader attempt to criminalize being Palestinian. It is part of the Israeli campaign of ethnic cleansing of Palestinians that is active in the West Bank, the Gaza Strip, and all of historic Palestine. Of course, it has been very difficult. Our capacity has been severely impacted. Funding, targeting, anything and everything. Because our work is tangible, it's material, it's on the land, that also means it can be attacked. But we continue our work nonetheless. No matter what they call us, our commitment is and always will be to our community and to our land. As I said, we are caretakers of our land, and we will continue to do so, despite any designation that they may name us and any toasters they might steal. Thank you.
Thank you very much, Yasmin, for your intervention. Before moving on to conclusions and recommendations, we'd like to now open the floor for questions from the audience. We have about a few minutes for a Q&A session. So please feel free to ask your questions in English or Arabic. And please identify yourself and specify if your question will be directed to a specific panelist.
Hello, this is Sharaf Aziz of Justice for All International. I'm very grateful to MENA Rights Group for organizing this very interesting and important event. We are very grateful for your stories coming from MENA region. We are also working very actively in the field of protecting human rights defenders, journalists, political dissidents. But in our case, we have quite a number of people already whose rights were violated, including by United Kingdom police when it comes to the enforcement of terrorism law at the entry points, border crossings in United Kingdom, but affecting citizens of United Kingdom. So here we have present our participants of the event, which will take place at 4 o'clock today. And we would like to invite all to attend our side event in this room at 4 o'clock, where the same similar stories would be actually shared by our clients. Thank you very much.
Thank you very much. I'm Altaf Hussain Bani. I'm from Kashmir, representing World Muslim Congress. As we're discussing the counter-terrorism laws, which the states are using, I am myself a victim of those laws, and my whole nation is a victim of those laws, which India has enacted in occupied Kashmir. That the way you said the laws are vague in definition, and using those vague definitions, all our political activists and human rights defenders, not the ordinary human rights defenders, but the human rights defenders of international fame like Khurram Parvez, are languishing in the jail on the pretext of UAP, called the Unlawful Activities Prevention Act, which has a very vague definition, and anyone can be put behind. And myself coming here for the last 2 decades to this council, the Indian government is terming me as a terrorist for in their websites of the RAW and the government exchanges. That I always feel a threat when I approach the reprisals, the mandate. They also said that how can we save you? We can ask you to protect yourself, but your family back at home, that will be at risk. if your name comes in that. So this is a way how the states are managing these laws and protection, but we have huge human rights systems, but there is no accountability of the states at any level. I always say when we had this UPR, we thought that it will be a very good mechanism to make states accountable. But we have seen this has become you scratch my back, I scratch your back, because none of the states has been made accountable for what they are doing by using these laws against their population or the people who do not agree with them or criticize their policies. Thank you.
If there are no further questions, we'll move on now to conclusions and recommendations. Samar, looking forward, what are some of your recommendations to states or other stakeholders to remedy or mitigate the adverse impact of administrative CT measures on human rights?
Yes, thanks for the question. So throughout the presentations and my presentation on the High Commissioner report, we heard issues related to definitional issues, broad definition of terrorism, extremism, and so on. We also mentioned that there is no definition of administrative measures. We heard concerns about transparency of procedures, lack of access to information, ineffective safeguards, and oversight. We also heard that there is limited evaluation of the effectiveness of administrative measures in counterterrorism. And as we heard also from panelists, there are grave and disproportionate impact on civil society actors and human rights defenders in the context of counterterrorism. And here I'm going to focus, of course, on the administrative measures. Please note that we have previous reports by the High Commissioner that addresses other thematic areas in the field of counterterrorism and human rights. And I have left just outside, in your exit of the room, there are some briefers that I welcome if you can take some. So the key recommendations by the High Commissioner, one, we do, of course, acknowledge that terrorism remains a real threat to security and international peace. All measures, however, have to be in compliance with international human rights law. And while administrative measures provide a tool for states to address aspects of the threat of terrorism, we have heard about the extensive impacts on human rights. As a first step, the High Commissioner recommends that all legal frameworks and definitions should be accessible, precise, and clear to avoid misuse and overuse of the CT framework. Procedural safeguards are a must in this case, and effective oversight, especially when administrative measures look like criminal action. In such cases, all the procedural safeguards used in criminal law should be applied to administrative measures. The High Commissioner also recommends states to avoid using administrative measures to bypass the constraints of criminal law. And to that end, the High Commissioner advises that there is a need of regular independent monitoring and evaluation mechanisms of the effectiveness of administrative measures. And in doing so, states are encouraged to involve civil society actors, human rights defenders, and others in the course of evaluating the effectiveness of such measures. On listing specifically, we would recommend that any human rights defender, civil society actors who are listed unlawfully in those lists should be removed and have access to effective remedy. And finally, on the deprivation of nationality, we highly recommend that it is not employed as a general policy to counter terrorism. And if used, it should be reserved to the most exceptional circumstances with effective safeguards and oversight. Thank you so much. The report will be presented to the Human Rights Council on the 18th of September in the afternoon, along other thematic reports by OHHR. Thank you.
Thank you, Samad, for sharing these recommendations with us. Now, lastly, Yasmin, Ahmed, Abdullah, and Tanya, do you have any final thoughts or any recommendations that you'd like to add to states, to the UN, to the international community, or any other relevant stakeholders? Maybe we'll start with you, Yasmin.
Thank you, everyone. It's very clear that the international systems that have been meant to protect us have failed. They failed 76 years ago when they allowed for the international integration of settler colonialism, and they have continued to fail since. But this failure has never been more clear than it is right now, nearly 1 year into genocide. These are not isolated failures. Genocide and famine do not happen by accident. They are manufactured. The catastrophe that we are in right now, this is human-made. The irony in all of this is that it should be very easy for duty bearers, particularly states, to take immediate and urgent action. States need only to abide by their legal obligations. International law calls upon states to take all possible action to not aid and abet human rights abuses, occupation, genocide, ethnic cleansing, land theft, forcible displacement, marginalization of indigenous communities. The ICJ recently determined that the presence of the Israeli occupation in the West Bank of Palestine is unlawful and must end immediately. The ongoing ICJ case about genocide has pointed to Israel's committing genocide, plausibly. States have a legal obligation to immediately respond. Have they? Is their choice not to respond? Is that not terrorism? States must immediately impose, at the very least, economic sanctions, arms embargo, rather than being complicit and continuing to actively participate in the genocide of Palestinians. Instead, we are continuing to witness genocide. Active ethnic cleansing campaigns, the intensification of the situation in the West Bank, as well targeting of Palestinians all over of historic Palestine. Where are the counter-terrorism measures protecting us? Besides states, individuals also have obligations to stand with justice. Children in Palestine are starving. Is it odds that your children were not born there? Is that luck? As individuals, we have obligations to values, to human rights. As citizens, we have obligations to ensure that our states do the same. Corporations have obligations, organizations have obligations. Justice is inevitable. We all know that. But the real question is, what will you do to ensure that you will be on the right side of history when we get there? Thank you all for your consideration and for listening.
Ahmed, any thoughts?
Well, many of the conventions in the field of human rights were signed by the UAE. And the UN is concerned with this, definitely. Nevertheless, in fact, the UAE government is not implementing any of them. And you can imagine, just for example, the Convention on the Abolition of Terrorism, of torture. But what is happening rather in the UAE, they put people for 3 years in jail, in isolated jail. And of course, by itself, I don't consider that we need to classify it as an amendment. And for the general preamble, for the in the presentation for the Human Rights Council in the last session in 2023, the UAE actually had listed a series of considerations regarding to the violations of human rights. What happened since that list? But we realize that the problem is aggravating, it is escalating, and actually it will be contagious. It will impact not only the UAE, but also all the region for all these dictatorial measures. And this will impact all the peoples of the region. As long as the UN does not sense the importance of this problem, and the foreign and the international community, if they are not made aware of this, and for all these measures, criminal measures against the peoples, I tell you very frankly, very openly, requesting the UN as well as all the friendly states of the UAE to release the ones who ended their sentence for years, and of course all those who are still in jail. What they are supposed to do is to ask for their release, for their freedom, and in order to know what is happening in the UAE, they have to check on this. And all those who agreed with the UAE, actually UAE signed some conventions. Whoever is signatory of the convention, where does the implementation stand on the ground? So there should be control on this. And many international actors came to the UAE, and they did not even have access to the detainees. And actually, some of them were even banned from coming to the UAE. There should not be silence about this. One more thing, actually, the fair trials in the UAE, everybody is faced with this, whether the Emiratis themselves, the citizens, and even the visitors. Some people visited the UAE, they had transit only. They were actually arrested at the airport, and they were actually isolated in jail, and nobody knows what is their future. And we have daily measures as such in the UAE, and I gave you my own personal example. There could be even more severe cases, and we might not be aware of such cases. This is why the international organizations and this noble, great organization, they should strive for the implementation of the human rights. Actually, the freedom of expression, freedom of expression of conscience, of thought, and also political participation, they should all be guaranteed, and there should be accountability. The UAE government should be made accountable also for what it is doing towards its citizens. Thank you. Abdallah, you have the floor. I thank you. In terms of recommendations, amongst the recommendations, the international community, including the UN, should take the travel ban as a serious issue, and also to set new special committees that work to prevent such measures. And we would like to thank the report of the High Commissioner also regarding actually the freedom of conscience, and also all the people, and the technical committee working on non-discrimination against women to interact with the authorities in Saudi Arabia, also in order to free Lujain al-Hazloul and Mariam al-Kutaibi. We would like to draw your attention on such violations, but this helps also in that, because the authorities themselves are giving different stories also about the international about the cases, and we need to refer this to the concerned authorities in order to preserve the human rights. Thank you.
Thank you. I think just in general, from what we've heard today, it's important to understand and to take into account the grave human rights impact, not only of criminal counterterrorism measures, but also administrative measures in counterterrorism. And it's important that the conversation doesn't stop here today. So we'd like to say to the UN, particularly the UN Counterterrorism Architecture, the Special Rapporteur on Counterterrorism and Human Rights, to take in what was said today, to consult with civil society who are directly impacted by these measures, and to advise states on how to change their laws and their policies accordingly. And to UN human rights bodies, including special procedures, we encourage you to continue to engage with civil society, to receive our reports and our appeals, and to continue sending communications and recommendations to relevant states and bodies. And to states, we would like to say, don't ignore what your people are saying. Listen to their stories and the ways in which counterterrorism measures and policies impact every aspect of their lives, and use them to revise your policies in line with international human rights standards. Thank you.
today's important discussion. Thank you.